All right, good morning, everybody. All right, so before we get started, I will introduce my wonderful co-panelists. I'm Bradley Gerard. I'm litigation counsel at Americans United for Separation of Church and State. Very impressive folks up here. I'm not going to read their bios because we don't have much time. Sitting next to me, Nora Benavides, Senior Counsel and Director of Digital Justice and Civil Rights at Free Press. Next to her, Tabitha Abu-El-Haj, Professor of Law at Drexel University's Klein School of Law. And then at the end, Jody Rabhan, Chief Policy Officer for the National Council of Jewish Women. So thank you, and thank you all for being here. We're here to talk about the Roberts Court's weaponizing of the First Amendment. And there's a lot that we could cover. But since we don't have all weekend, we're going to have to leave some out. So here's what we're going to do. Given our respective areas of expertise, we're going to focus on religion and speech, or speech broadly defined. And although there's enough in each of those areas of the law for us to be up here for hours, we aren't just going to talk about where the law is and where it's going. We will, to be sure, sketch out a bit of the landscape, but the principal focus is going to be how the court's jurisprudence fits into our conceptions of what the First Amendment should mean, and what role we envision the First Amendment playing in a progressive movement and an ideal democratic society. The overall theme is going to be one of balance. In both the religion and speech contexts, the First Amendment is often framed as a balance of competing interests. In religion, there's free exercise rights on one side, that is the personal right to exercise your religion, and establishment clause concerns on the other side. That is making sure the government doesn't prefer or promote any specific religion. As for speech, everyone's familiar with the various host of considerations that are often discussed. Free speech versus equity, or safety, or market regulation. Now, we know how the Roberts Court has come down on these balancing questions, and we'll certainly touch on that. But acknowledging that isn't enough. We need to think about how do we respond to the court's framing of the First Amendment? Do we fight to tip the balance back toward what we think is the proper balancing of the First Amendment? Or do we try to use the Roberts Court's rulings toward progressive ends? Do we reject the idea of balancing in the first place? And if so, how does that look? So here's how the discussion is going to go. We'll start off talking about what the court has done in the religion context and what's coming down the pike. Through the lens of religiously motivated discrimination and reproductive justice, we'll talk about some potential responses, their benefits, and some of the possible pitfalls. Then we'll pivot to speech. With a case like 303 Creative, it won't take much to see the combination of religion and speech. But we'll also talk about Counterman versus Colorado, that's the true threats case. And of course, we can't talk about the shape of the First Amendment without talking about the internet. So to start it off, I'm going to start with Jody. Jody, we're a year after Dobbs. So can you kind of give us an idea, sketch out the landscape a little bit of reproductive justice and religion a year out and how that looks?
Sure. Hi, everybody. I just want to thank you, Bradley, and just thank ACS for this incredible conference and, of course, this really important conversation. As a reminder, our country was founded on the principles of freedom of and freedom from religion. And fast forward, right, here we are, almost a year out from the Dobbs decision, Dobbs versus Jackson Women's Health Organization, and we find ourselves where the highest court of the land has codified one narrow religious interpretation of when life begins. This court has done a lot of shocking things for the Jewish community, for people of faith, people of minority religions. This was epic. It was a real wake-up call to folks who hadn't necessarily paid attention to this court, hadn't paid attention to reproductive health rights and justice issues, and really sounded the alarm for folks. At National Council of Jewish Women, we've been talking about these intersections of religious freedom and the courts and the issues that we care about and have been mobilizing and organizing for decades. In fact, when the court decided to take this case, it was a wake-up call for us. We launched a Jewish Abortion Access Coalition. We started a whole campaign knowing, right, what was coming. We hated to be right in this instance, and we were. And in so doing, we're able to help galvanize our interfaith partners. We also launched into an area that was a little bit new for us, litigation. So we had been called upon to lead interfaith amicus briefs in the past. We did one for the Dobbs case. And as we had those conversations, there were a lot of questions within my organizations. We should be a plaintiff. We should bring a case, right? As a minority religious faith, though, let's assume the case has a good outcome. It doesn't impact a whole lot of people. It would impact, right? It would impact our religion. If we bring some Hindus, Sikhs, Muslims in with us, other minority faiths who share a similar belief about when life begins that is antithetical to what the court decided in Dobbs, it doesn't really get us to a place where we want everyone to be able to access the health care that they need, that they want, whenever they need and want it.
So let me ask, when you're making these decisions to bring these sorts of cases, there are really tough issues there in terms of, okay, this is what we're given, right? And we can increase abortion access for a small number of people, but it's still a number of people. What are the dangers that you see in going after that kind of litigation? Even though you don't get everything that you want, you might get something good, but what are the dangers?
Well, we also might not get something good. So, that's we don't want to be responsible for creating bad law. We're also aware, right? You mentioned reproductive justice in your remarks, and that is a movement led by Black women. It is the ability to be able to parent when and if you want to parent, to be able to parent in safe communities, to be able to decide for yourself, right? The kind of family you want and when you want it. We recognize that at the center of all of these bans and restrictions on abortion, it's primarily Black women, people of color who can get pregnant, and we recognize that it's not us. So any case that we might bring, again, Jewish women, folks in minority religions, it has the possibility of just creating a very narrow opportunity for folks that ultimately wouldn't help the people who are most impacted by abortion bans and restrictions.
And do you think that there's any potential danger for the law more broadly in that, so say you're successful and a court says, okay, fine, we'll give you some limited abortion access, but now we're creating precedent about using religion to get out of generally applicable laws. And we're seeing plenty of that. And so just if you could talk us through a little bit your thoughts and kind of balancing those interests.
I would say bingo. That's exactly right. I see a lot of heads nodding. That's exactly right. We've been so focused on the cases that have come out of this court, the COVID cases. I know we're going to get to a couple of others here today, and I'm going to leave it to the attorneys, but how religion, certain religions, a religion has been prioritized, and how dangerous it could be if we jump into that fray and what that could mean, much broader.
Yeah, and I think one of the kind of broader issues, the broader questions that I was really happy to hear a lot about last night, and I think is underlying a lot of these discussions, which is, kind of what is our ideal democratic society? And yeah, we might want to fight for a victory, and a small victory is still a victory, but are we potentially playing into to a ordering of society that is, ultimately pretty troublesome? And that's to set aside the legal realist way of thinking about it, which is, we might want the courts to be consistent, but the chances are that they're going to be ruling in favor of minority religions or claims that they don't see as being all that important versus the majority religions or the mainstream religions. There's a danger there too. We actually have our organization has a case in Tennessee in which a state-funded private religious adoption agency turned away our clients for being Jewish. And the state is somehow defending all of this. And one of their arguments was, well, look, any other religious organization that sets up they can choose to just serve their religion. And if you think about it, that's a pretty terrifying thing, right? The answer to discrimination is not more discrimination. And I think that there's a risk of kind of playing into some of that. We'll come back to some of the religion stuff, but I want to turn to Nora now to talk about the landscape of speech, everything speech-y. There's a lot there, so I'll let you start off.
Sure. Thank you all for being here. I have to say, this is my favorite topic. I imagined we would have 4 or 5 people basking in what it means to counter the weaponization of the Roberts Court regarding the First Amendment. And we're here, and I'm watching chairs be brought in so that more people can sit, and it's making me very, very excited. So we're here all together. And Bradley has now tasked me with explaining the entire history and arc of what free speech means in this country and maybe beyond.
Just wait till I ask you to talk about the internet. So.
He did, and he capitalized the I, so we know it's real. Well, I guess I think a lot about what not just legally free speech and expression mean, but philosophically what the sort of underpinnings are in democracies, what expression, engagement, real connection should look like. And of course, where do you go when you don't know what that looks like? You go as far back as you can. I often go to ancient Greece and other ancient societies. And I think about where we are now, what we think of as division, that speech often seems to be a proxy for feeling heard and being listened to in a way where you are agreed with, and anything that we disagree with, largely we do not engage with. That's really where we are right now. We're in a very tense political speech situation. And as far back as I can go, that's really only one school of thought when it comes to expression. Many competing theories around what speech should look like have been debated for centuries. My favorite, in all candor, is a term called isagoria from ancient Greece, which refers to the equality of free speech. In ancient Athens, people who couldn't afford to make it to the public square were paid to speak in front of others. The idea being that we should all have the opportunity and the access to come before our fellow citizens and talk about issues of the day. That kind of equality of speech, which I know we'll get into when we talk about equity and safety, has really been lost. And over time, throughout society, what we've seen is this kind of, surge of something else, something that really allows us and comforts us in the ability to say whatever we want, the ability to speak, and that alone is what free speech means. I think the Roberts Court has helped kind of bring that to a preeminence. And so people often say, well, we're more divided than ever. No, we are not, actually. In old colonial US settler communities, people were so divided that individuals who disagreed with philosophies that the majority espoused were removed from communities. They were forced to leave. So I just often challenge the presumption right now that where we are is somehow new and different. It is new for certain things, but it is not new because we are more divided. However, the Roberts Court has, since Roberts took over as Chief Justice, has really taken on about 60 free expression or free speech cases. Of about those 60, a majority have been written with majority opinions. That shows us that within our highest court, there is actually less division regarding speech than there is among you and me and our fellow citizens, civilians, people that we might connect with in our communities. That troubles me. That means that somehow there is a kind of special and tighter interest of issues regarding free speech and the First Amendment. All of this against the backdrop of really a kind of narrowing of free expression rights. And I know we heard a little bit from Justin Pearson last night about this. What we've seen over the last 10 years is every single legislative, judicial, and executive branch around this country interested in tightening, in narrowing what our basic free speech rights are. Whether that is how we can vote, how we can protest, what we can read, what we can say, the types of activities students can engage in. These are becoming narrower and narrower and narrower. And against that backdrop, the court has continued to select a majority of commercial speech cases, not cases that would deal with these fundamental expression issues. So I give you this context, hopefully just to show us that where we are, it's tenuous. It's a situation where I think we are, frankly, fraught with disagreement about how we define this moment. We like to say easy headline things like, we're more divided than ever. But what does that really mean? And so what I challenge us to do in this conversation, and frankly when we leave here, is really start speaking more clearly about what the First Amendment means, what free expression looks like in all of our lives, because that is not the majority of what the cases are that the Roberts Court has taken. I'm so pleased to hear people like Jody who are talking about and contextualizing why Dobbs is so important. Those are the kinds of everyday expression speech issues that we have to be talking about.
So to kind of turn from the broader to a little bit of the more particular, I want to ask Tabitha if you could talk just a little bit, give a quick rundown of these two really important cases that I mentioned, 303 Creative and Counterman, and then we can get into some more of your conceptions after that. But I think it might be helpful for everybody to just have a brief rundown.
So I am delighted to be here and a little bit sad that I got the boring task of telling you about what the Roberts Court's going to do. But here we are. So I'm going to tell you first about People versus Counterman. The case is coming out of a Colorado appellate court, and it involves a appeal by Counterman for his conviction for stalking a public figure. The public figure was a local musician. And what he argued, and this will tee up, I think, some of the issues that I hope we'll get to talk to, is that it violated his free speech right because his conviction was basically included evidence about messages, speech, that he sent to her over Facebook. So Counterman argues more specifically that his statements, although threatening, did not rise to the level of a true threat under the Constitution because they were not explicit statements of a purpose or intent to cause injury or harm to her. And the Colorado Appellate Court, although it rejected, the challenge, holding that his statements were indeed a true threat, unprotected by the freedom of speech. I think it's a really interesting question whether the Supreme Court will affirm that. Counterman follows another case that some of you might have heard of before, Alonis versus United States. In that case, it was a challenge to a federal law that prohibited, quote, any communication containing any threat to injure the person of another. There, the facts were a messy divorce where the soon-to-be ex-husband posted on Facebook again speech, quote unquote, that was described by the court as crude, degrading, and violent about his soon-to-be ex-wife. And the court actually struck down the prosecution, finding that the prosecutor had failed to prove that he had a mental state that was intending to cause a true threat, as opposed to that a reasonable person would have found the communication threatening. So we'll come back to this. I mean, I think for me, the issue with these cases and the broader question about how both the court and I think to the consensus point that Nora made, how I think also liberals accept this premise, I think the real problem I have with that case is this idea that if there's any speech involved in the conviction, then there's potentially a free speech issue. And I think we don't really have good answers yet as a community to that kind of claim. Then 303 Creative LLC versus Alonis, and I might have said these last names badly, and I apologize for that to Alonis. This is a case I think that more of you will have heard of, I assume. There, the challenge is to Colorado's Anti-Discrimination Act, again, on free speech, free exercise, and vagueness and overbreadth grounds. The statute prohibits a public accommodation from refusing service on the basis of a customer's identity, and in this case, the customer's identity is their sexual orientation. A public accommodation is defined as any place of business that engages in any sales. That's the relevant part for this Creative LLC, which is a graphic and website design company. the company claims to be willing to serve the LGBTQ community, just not with respect to wedding services, because the sole proprietor sincerely believes that same-sex marriage is against God's will. So she has said that she would refuse to create custom graphics that promote any ideas that she objects to on religious grounds, whether that was any content that, quote, contradicts biblical truth, demeans or disparages others, promotes sexual immorality, or supports the destruction of unborn children. She would like to announce this on her website, that she will not condone or promote same-sex marriage, and Colorado believes this violates the public accommodation law. The case follows another case that you all probably have heard of, Masterpiece Cake Shop. In that case, the court sort of dodged the free speech issues, decided it very narrowly, with Justice Kennedy being, what I don't know what we'll say about Justice Kennedy. He's not with us right now, but he decided on factual grounds. The 10th Circuit did actually uphold Colorado's anti-discrimination law, including the prohibition on her desire to express her refusal to serve same-sex marriages on the website. But here's the thing, they actually conceded that the law amounted to compelled speech, and therefore subjected it to strict scrutiny. Where they came out differently was in the balancing. Colorado's, the 10th Circuit said that Colorado did indeed have a compelling state interest in protecting both the dignity interests of the members of marginalized groups and their equal access to the market. And then when it applied strict scrutiny to these two aspects, it said both provisions, both the provision banning discrimination on the basis of sexual orientation and banning statements about your views about same-sex marriage and not being willing to serve those people, passed strict scrutiny only with respect to the equal access to the marketplace rationale. But, and here's one thing I want to highlight, even the majority found that public accommodation laws are particularly worrisome, and this is something I would hope we'll get to talk about, because the 10th Circuit's view was that they take a stand on a controversial topic and thus create a, quote, substantial risk of exercising certain ideas or viewpoints, excising certain ideas or viewpoints from the public dialogue. In fact, they characterized the CATA, which is the short form for this act, as having a very purpose of eliminating such speech. And I guess just to preview my position is the point of a democracy is that legislatures can take views on public moral issues and equity and other things. And so this sort of singling out public accommodation laws as sort of an inherent threat to speech, I think, is what we should unpack. There's a dissent there from a judge, Tomikovic. He says, and again, I think this is a sort of frames the debate, and I would like to problematize it. He says, if liberty means anything at all, it means the right to tell people what they did not want to hear. Quoting George Orwell was talking about, I think, a particular place where one might be able to do that. But again, he, like the majority, shares this view that public accommodation laws are somewhat, he frames it more starkly, are at odds with the Constitution's endorsement of pluralism of belief because they amount to laws that say you can't say that. Usually applied to religious-based speech. So I think this gets at the heart of this question of why is there so much consensus on the Supreme Court, and maybe we can unpack that. I will say one other thing about the case, which was oral argument was just like a mess, if any of you listened to it. It began with the wedding planner's lawyer, well, the non-wedding planner's lawyer, the designer's wedding, who basically said, well, is their speech, obviously their speech, because there's words on the website. And I think that's really the question, is that obvious or not? And is the message affected? And if the message is affected, then basically case closed. This then threw the justices down a rabbit hole of hypotheticals, totally unmoored, in my view, from any first principles. So we got discussions about plug-in websites, about Alex and Alex's wedding, about photographers only willing to have a white Santa and white kids in their photos because of their nostalgia to the 1950s, followed by Justice, I think it was Alito or Gorsuch, one of them, who said, well, what if you refuse to take photos of kids in KKK outfits who may or may not be black. I mean, it's just like a nightmare. And that's sort of my general view about the free speech doctrine, is that the upshot is it's convoluted.
And this court.
Convoluted, because they don't really have, not just the conservatives, but the liberals too, really struggle with how to think about the line drawing problems.
And I think that, the instances that you brought up, the kind of conventional wisdom is that these are hard issues, right? They're hard issues precisely because of the balance that the court has helped to frame that the conventional wisdom is around the First Amendment, right? That it's, you've got artistic expression and you've got public accommodation laws, or with countermen you have you've got safety versus free speech, right? And we're seeing that, and we'll talk a little bit, Tabitha, I know that you've written about this, especially with the kind of generational difference in terms of free speech absolutists versus people who are focused more on equity in speech. But you have this wonderful article, How the Liberal First Amendment Underprotects Democracy, and I encourage everybody to read it because at the core of it is really calling into question these balances, right? You're saying, look, this is just a wrong conception of the First Amendment. This isn't it shouldn't be speech versus equity or speech versus safety. You're already kind of losing when you're analyzing it that way. And I think you would say that that's the problem with the liberal justices' conception of the First Amendment as well. And I know Nora has talked about this too, so I would love just to hear a little bit about why you think that the traditional conception of it is wrong and how we should be thinking about it.
So at a very basic level, I think in my experience, every time you set up a balance that's speech versus equity, equity loses. So the question is, why? On the other hand, I think to the sort of generally younger, more progressives who say, well, equity should always win, I think that maybe they are, I'm going to date myself, insufficiently skeptical about who's in charge. Because in my experience, when speech loses, it's not going to be the corporation's speech that's going to lose. So how do we then thread the needle between this paradigm where both parties are right and neither of them can communicate? And I generally think that, though I date myself about to the generation that's more sympathetic to strong First Amendment rights, I do think we tend to be condescending, honestly, when speaking to younger progressives. And so this article is really an effort of mine to sort of think differently about it. And I guess what I think is that liberal and progressives have accepted a construction of the First Amendment that's mistaken for a number of reasons. One is, and this we won't have time to talk about, is it privileges expression over all these other forms of political participation and doesn't recognize that actually the First Amendment protects participation. And so public assembly is a really good example of that. Public assembly is protected as conduct as long as it's peaceful, and we don't talk about that enough. The second, as I said, is that it's sort of unmoored from principle, and that what we've seen with the Roberts Court is that it's taken that unmoored conception of the First Amendment to its logical conclusion, and the upshot of it is that we undermine democracy all the time. And so in this context, if we go back to the oral argument in Elenis, when the wedding planner said, "Is there speech?" and everyone in the room said, "Yes," right? There's words on this website. I would say, I think that's not the right way of thinking about it. We tend to think about the First Amendment as prohibiting any abridgment of speech, but that's not what it says. It says it prohibits the freedom of speech. And my argument is that the First Amendment works differently than other rights. Most other rights really do take an issue off of the political agenda. So slavery is the clearest example. 13th Amendment bans slavery. That means we cannot have democratic deliberation about the pros and cons of slavery. And the same with the Second Amendment. We might have a debate about the scope of the Second Amendment, but the scope of the Second Amendment says there is some right to own guns. Liberals and progressives have accepted that the First Amendment works the same way. There's free speech. I get to say what I want. That's the whole problem with the George Orwell quote. Free speech, if it means anything, you get to say what someone else doesn't want to hear. But I argue that the First Amendment actually structurally works different, that its protections are about they are negative liberties that are set up to protect the possibility of democracy. And so if you think about it that way, then what we have is the overarching commitment of the Constitution is to a Republican form of government, a form of government where we self-govern. We can have different views about how democratic it has to be, but that's the idea. The First Amendment makes sure that that democracy is possible, that there isn't going to be an entrenchment, that it is not impossible to change the terms of the debate. But if you think about it that way, then you need to recognize that it is not an absolute prohibition on speech regulation. It is a prohibition on speech regulation in what I call the domain of politics, in places where your inability to speak impacts whether or not a political process really broadly conceived in my mind to include culture, to include individual autonomy, is being impacted or not. If you then take that's distinct from what I would call a domain of governance, which is the place where we've made choices. Colorado has made a choice that actually it thinks democracy includes equity, and you should have equal access to the marketplace regardless of your identity. Texas may not make that same choice. That is two different. We could have a whole other conversation about whether we like federalism or not, but our Constitution has structured it that way. In which case, I think actually there are lots of hard cases and there are lots of line drawing problems, but 303 Creative LLC should be an easy case because it is a woman selling a product in the market to people. The government can decide what the terms of the market are. We say you can't discriminate on the basis of race in employment. We should be able to say that you can't discriminate on the basis of sexual orientation in selling wedding services. That's sort of, I think that we've lost that ability to distinguish because we have assumed that the First Amendment functions like the Reconstruction Amendments, or we've conceded this without thought, which is actually really what I argue in that article, is that we've just sort of stepped into this without really theorizing how the First Amendment works differently. And I apologize for going on for too long, because I'm very passionate about this, and this is why I accepted coming, because I have a whole room full of progressives, and I want to say, please stop the next time you say, oh my God, you just, ban someone's speech. I would encourage you to think, well, speech or freedom of speech, because I think those are two different things.
Before we continue on, for folks who have CLE, the second code word is FIG. Now back to our scheduled programming. So I'm interested in, and anybody can jump in on this one, the issue of art that's in the marketplace, right? I mean, it's a commodity, it's sold, and it sounds like your position on governance is, marketplaces can be regulated. How do you see those two as kind of interplaying? And again, anybody can jump in and take this.
So I guess I'm curious as to what you think the worry is about art. So I think lots of things in the public sphere, what I would call the domain of politics, are also commodities in the sense you buy your newspaper. You actually also buy access to the internet. You just don't know that you're paying for it. You're paying for it with your information. And I think books are always sold. So when I think about the domain of politics and the domain of the market, it's really it's not so much that there wouldn't be commercial aspects to the domain of politics, but that we think about the domain of politics as where is it that we get ideas that shape culture? Where is it that we get the ideas that shift to social movements where now we are talking about same-sex marriage? And that is going to have to include literature, whether it's sold or not. It's going to have to include art. And there will be some cases, I think, where there's a borderline question. And I think the true threat counterman is sort of an interesting case in that way, in the sense that the woman is a public figure. So there is going to have to be some insurance that whatever our criminal laws do, they do not impede the ability to criticize public figures. But I think we would set up the presumptions differently, in the sense that we would set up the presumption as in the most run-of-the-mill case, the criminal law, whether or not the evidence includes your speech does not make it a First Amendment issue. But there might be other types of criminal cases that involve public figures, where we would want the court to be carefully figuring out how to adjudicate that line. So, but I guess my big thing is I don't think there's a huge threat of regulation of art, but I do think there is a huge threat to the way that the First Amendment is being used in regulating the to deregulate the economy. Those are fights that I think should be happening in the legislative domain, and instead what we're having is fights constitutionalizing particular conservative outcomes through the First Amendment that are really about economic regulation. And Nora, you might have a different perspective or similar, but you sort of teed that up a little bit about the court keeps taking these commercial speech cases and forgetting about everything else, and I think we should wonder about why.
Well, I'm pro-art. Just feel like nowadays you got to say where you stand. Frankly, when you asked the question, Bradley, the first thing I thought of were book bans, because that's what I've been looking at almost exclusively in the artistic realm. And I'm very concerned, primarily because of what the impetus is for book bans generally. What books are being banned? Books that portray and place LGBTQ individuals as protagonists, about slavery in this country, about people of color, immigrants, what are largely underserved or underrepresented voices. And I would probably put those words in quotes, underrepresented in some way. That the arc is moving further and further from justice, further from access to allow people to just check out a book at a library, somehow points to a really troubling future for us when it comes to artistic expression and the ability for all of us in our communities to get those stories. It's so important for children to be able to see themselves in something, and that is becoming harder and harder. Hundreds of book bans have been introduced through legislative actions, executive orders by governors, and other local and state actions. On top of that, there is this additional layer of legislative action by states when it comes to what people can be taught. It's currently called like CRT legislation, critical race theory. There are some wonderful reports. UCLA has done a study of the anti-CRT legislative trends. I would encourage you to check it out. It's really tremendous. It looks at sort of what the underlying lies are that have helped fuel this movement, which conflates something like CRT and relatedly book bans with communities that are underserved, that somehow they are violent, that they are in need of being legislated and regulated. So I think in a lot of theory, I agree with Tabitha, at least from the outset. But in practice, what I'm now seeing, at least in this one context, troubles me so greatly that I have to wonder why this trend is playing out with such force, and what it will mean as these cases move through our courts at the lower levels and eventually at the higher, Supreme Court level. They permeate every issue, and we could spend an entire day talking about the commercial speech trends from the Roberts Court. We could spend an entire day really going through why has the court selected to review and rule on cases about corporate speech, about how people are related to large entities. Why are we not really hearing a majority of cases about speech that we practice every day? But we don't have all of that time. So I'm going to turn it to Bradley to talk about the internet.
No. I think we're not even going to have time to talk about the internet. We're going to have to open up for questions in just a minute. But there is something that I wanted to talk about that kind of ties a lot of this together. First, just a clarification. When I asked the question about art, I know you're concerned about books. I was concerned about the folks at Subway, the sandwich artists, and what side of the line they fall on, and if they are adequately protected. No, but going back to something that I thought was really powerful last night from Sherilyn Ifill talking about power, and thinking about it as legal realists, kind of how some of this is just exercises of power, and how we have to think about it in kind of conceiving what our response is, the realist response, but also in how we want to conceive things. So to bring it back to religion, what we're seeing now, especially influenced by Bostock and Obergefell, is this enormous push for some statutory stuff, but mostly under the First Amendment, for religious institutions and organizations to just opt out. They don't like that LGBTQ folks are protected in a certain way now, and so they're trying to use all of these various doctrines, free speech, freedom of expressive association, and there are two that are really troubling to me. These are two that I work on a lot, the ministerial exception and the church autonomy doctrine. There's the potential, if the other side had their way, that 2 million employees of religious employers, lay employees of religious employers around the country would lose all fundamental civil rights protections. Title VII, Americans with Disabilities Act, all of that. And then we see it with 303 Creative. There's no shortage of places right now that we're seeing in the law this idea of just using the power, using the court to opt out of basically to opt out of democracy, right? There are a small minority that do not like the way that things are going. Instead, they know that they've got these doctrines and this power behind them. And so I think it's something that we really do need to be thinking about in this broader sense when we're talking about balancing and we're talking about doctrine, not to throw it aside, not to be nihilists about it, but to really be thinking about how that plays out in our vision of democracy and what that means for power. If anybody else has anything.
Jump in on the art.
And I want to get in after. Go ahead. I want to get in after you and put a final point.
I just want to say about the art. I think one of the things about is that if we don't have a theory, when those cases come to the Supreme Court, probably they will come out, and I think those laws will probably get struck down. But if we're in a balancing framework, all they're going to see is this is equivalent to anything else. They're not going to be able to see why books are really important in the domain of politics, because we don't talk really substantively about the role of the First Amendment and democracy. And then there's the risk that they'll say, well, these parents have a compelling state interest in their religious beliefs, and we could go down a different set of rabbit holes. So I think that's really what, I don't want to diminish the art issue, but I just want to say, I think that the framing is super important, and that balancing alone has some risks. Go ahead.
And the finer point I just wanted to put on your comments, Bradley, is I think many of us know this. It's a very strong minority, well-financed, well-organized, with a decades and decades long strategy to go not just after abortion, right? But it's the book banning, it's LGBTQ people, it's contraception, and with the effort of passing laws in states to get through the courts. I could be here all day talking about the federal courts, find me outside, and the importance of the judges on them. But a whole concerted effort to stack the courts and to introduce bills, get those bills to go through the state legislatures, through the courts, up to the Supreme Court, with the sort of impact of chipping away to where we are now, which is this sort of landslide, if not a door kicked open to the place that we find ourselves.
So we've got about 10 to 15 minutes left. I'd like to open it up for questions.
The online question first so that we get that out of the way. Thank you. And I want to repeat, willow and fig are the CLE words, willow and fig. So this is from somebody viewing virtually. Wouldn't the free exercise of religion found in the First Amendment not only protect minority religions, but also anyone who wants to exercise their abortion rights and disagree with the view underlying SCOTUS's implication of when life begins? And Jody, this was directed to you, but obviously anybody please jump in.
Would you repeat the question? Thanks.
Hello? Okay. Wouldn't the free exercise of religion found in the First Amendment not only protect minority religions, but also anyone who wants to exercise their abortion rights and disagree with the view underlying the Supreme Court's implication of when life begins?
Thank you. And really, I invite anyone to jump in. So, I think the question touches on what I said in the beginning. So, in Judaism, there is, found throughout our text that there is a permission to seek abortion care, if not a requirement, when the health and the life of the pregnant person is in danger. And it's not just in Judaism. So we find different interpretations of when life begins in the Sikh religion, in the Hindu religion, in the Muslim religion. People of faith, people of no faith, I would say across the country, by and large, believe and support some form of access to abortion. And where we are in this moment is an infringement on our religious freedom when we see these decisions like Dobbs coming out of the Supreme Court, when we've got the state legislatures passing restrictions and outright bans on abortion. We're seeing it in the context of medication abortion, sitting at the Fifth Circuit right now. And that is exactly where we find ourselves in this conundrum of being able to practice our religion, and it is at odds with what we are getting from the highest court of the land.
And I think, that question, to answer that question, you need to know what the free exercise clause allows or requires. And, there's an argument for, yes, this is required by the free exercise clause, and there's an argument that no, this isn't. This is a generally applicable law in this state, and like any other generally applicable law, you don't have a right to opt out of it. It's not to say that I think that's a good law or justified. I'm raising this because it does bring up these really tough issues of do you try to use the rules as they are, as they've been generated for a powerful minority, and knowing that that it's probably not going to go your way, but even if it does it just kind of blow open the door even more for somebody, say, who wants to discriminate in the workplace, saying, well, look, again, I've been told that my free exercise rights allow me to opt out of generally applicable laws. And I think there's a real danger to that on the ground. We're seeing that. We're seeing a lot of those attempts. That's what I mentioned with the employment stuff. But I think there's also just a real danger to a kind of democratic ideal of, look, we come together, we decide what the laws are, we decide who's protected, and people shouldn't just be able to opt out kind of wherever they see fit. I think the state constitution issue is a tricky one. I think there's definitely a role. I think there's more of a role for establishment clause, state establishment clauses to litigate there. But I think the court's been very friendly to free exercise, right? That's what they've really prioritized over the last number of years. So I don't think they really care all that much. The concern is that anything that comes out of the states that they don't like, they'll find a way to just strike it down under the federal Constitution, even when a state says this is different.
And the converse, did the Montana case essentially blow up state establishment clause claims?
Yeah, I mean, I think the state establishment clause claims are, it's a tough one, right? I think that there are states that provide greater protection than the federal establishment clause, and you know, we have to try to use those where it makes sense and take the constitutions that we're given, but also understand that because the Supreme Court, getting back to the issue of balancing, because the current Supreme Court sees the free exercise clause and the establishment clause as fundamentally in tension, as opposed to how they should be seen, which is working together, there's always a risk that any case that relies on a state establishment clause that the Supreme Court doesn't like, they will find a way to say, oh, well, this violates somebody's free exercise clause, and you know, that wins out. So it's a danger for sure.
And I'll just add that, along those lines, a group of organizations, including mine, National Council of Jewish Women, we've been working with attorneys, looking at state constitutions, looking at state religious freedom restoration acts, looking at state laws, looking at state courts, and a lot of the repro cases are starting in state courts, given the makeup of our federal courts, and also the way the state constitutions are written and state RFRAs, just as a likelier, friendlier environment as a start for some of these cases.
I'll just add, when I was a litigator, and I moved away from that a few years ago, I was in the Georgia and 11th Circuit. And I would think very carefully sometimes about where we were bringing cases, sometimes bringing them in state court with state constitutional claims. Most of the time I was practicing Section 1983 litigation, so I was in federal court, but I actually think that there are opportunities to be really innovative in the ways that we think about using state courts. And I would urge for the young litigators here, especially in the First Amendment context, to really think through with your older mentors how and when to deploy that based on, as Jody says, the makeup of those state courts, which can sometimes be a little more beneficial to your claims.
So I think hate speech is actually one of those places where I think the theory that I posed would give you a slightly different way of threading that needle. So I think it would not justify sort of a total ban on hate speech. But what it would do is really shore up the true threat doctrine. So I think one of the problems with the Supreme Court's true threat doctrine is, Virginia versus Black does not actually say you have a right to intimidate people on the basis of their racial or other other identity. It says it just has a very fine line it's seeking to draw, and I think one of the ways that if we had a better conception about what was in the sphere of politics and what was the domain of governance, we would be able to really shore up the idea that there could be criminalization of conduct that was threatening to individuals, because I think Thomas was right in that dissent. Cross-burning is inherently threatening. And Brandenburg, the cross-burning was not really, Brandenburg, the cross-burning was basically on a movie set, right? It was not a real situation. And as similarly in other parts of the article, I talk about if we think about public assembly as an independent right, I think some of these hard cases would also have a way of threading that needle, because in many of these cases, they are what I would say unlawful assemblies. Like they're creating a threat to individuals. So that's where, when I said about like, how could we move between the impasse between the sort of traditional liberal free speech expansionists and more concerns about equity, I think hate speech is actually an interesting place. Nobody's going to get everything that they want, but there's much more on the side of equity. I think if you broaden out the First Amendment to really think of the right of peaceable assembly as an independent right, and we really think about this distinction between about why true threats are an exception, and it's not just because they historically were an exception, which is our alternative current Supreme Court doctrine, which is we'll just accept anything that was in 3 categories, which is not very satisfying.
I think it's a great question. I also live in Georgia, and I'm familiar with the ebb and flow of those legislative proposals. We have like 4 minutes, and what I guess TLDR, I do not think we have gotten harassment, hate, and intimidation right when it comes to how we're really protecting people. That's the short version. The long version, briefly, is, one of my favorite questions that the courts have grappled with, and the Supreme Court in particular, in Brandenburg and the case law before that, is what is the line? Like, what is the line of unacceptable speech? Brandenburg moved that further towards allowing more unacceptable speech from decades of more conservative rulings. And I say conservative not politically, conservative speech-wise. So as more and more unacceptable speech was allowed, the kind of stuff that would offend or feel threatening or somehow distasteful, allowing that has, I think, opened the door for more and more harassment, people to feel unsafe. The Taylor Dumpson case that the Lawyers Committee for Civil Rights brought after she was harassed at American University is one of the best innovative examples of how to correct course and use unique, innovative claims where there are no hate crime statutes applicable. She was harassed online and in person, and it was really an interesting way to use various kinds of criminal statutes as well as tort claims for someone that couldn't really get at any other accountability. And so where our legislatures are grappling at the state level, there are some really interesting litigation solutions, and that's the short answer, but I'm happy to talk after.
All right, well, I think that's about all that we have. I've got just a quick announcement. We're going to break for lunch. If you've been assigned to a practice group lunch, you should have received instructions for time and place. For those who aren't participating in the practice group lunches, an episode of the ACS podcast, Broken Law, featuring Donald Sherman of Crew and Mark Joseph Stern of Slate, will be recorded live in the Ohio Room beginning at 1 p.m. Because it's a live recording, can't guarantee entry once taping begins, so please arrive just a little bit early. Look at the online schedule or the app for more details. There's always plenty of ACS people around to help you. I just want to say thank you to Lindsay and to ACS for putting together such an amazing event and a great panel, and thank you to my co-panelists for making this wonderful. So thank you.